Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item 12 on the main list. Item 12 and item number 1 is a connecting matter, Your Lordship. The conducting counsel.
Yes, I think item 12, like you said, you're correct. Yes. Connecting, matter. So first, we have to deal with item number 1.
Your Lordship, I'm appearing on behalf for item number 1. I'm appearing on behalf of respondent 2 and 3. For item number 12, I am appearing for the appellants, Your Lordship. They are connected matter.
We'll see. First, we'll take up item number 1. Then 12. Same order will be passed. We'll wait.
Obliged.
Please, Your Lordship. Your Lordship, I beg to make a mention of item number 13, Your Lordship. I humbly pray, Your Lordship, kindly this matter may be listed after Puja vacation, Your Lordship.
No objection, Your Lordship.
On pre-made by Miss Learned Counsel for the petitioner, seeking a composition. That is adjourned. Please the same after 2 weeks.
Lordship.
2 weeks.
Highly obliged, Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 11. I kindly pray for 2 weeks' time, Your Lordship. Conducting counsel is our station, Your Lordship.
This matter has been heard.
Not heard, Your Lordship. It was not heard.
Okay. On pre-made by the petitioner, this is matter of the 2 weeks.
2 weeks, Your Lordship. Obliged.
Really obliged, Lordship.
Lordship, I beg to mention item number 15, Lordship.
What?
My Lord, I'm praying for 2 weeks' time. If item number 15, my Lord, criminal appeal, my Lord. So I'm praying for 2 weeks' time if the matter can come.
Why?
Due
You
to
are in
some
this case.
Yes, my Lord.
Paperwork ready.
Paperbook ready, my Lord. It was hard also on.
Okay. Yes, you are for.
I'm for the appellant, Your Lordship. No objection, Your Lordship.
Mr. S. Gupta, learned additional PP, has sought for accommodation on grounds of personal difficulty. This will not be objected to by Ms. Learned Counsel for the appellant. Matters adjourned. This is same after 3 weeks.
What's up to the Lordship?
Hello.
Daily list item number 1.
Your Lordship, I'm praised for time, Your Lordship. In this, the conducting counsel may speak with the charges. You have some difficulties in this case. After Puja, Your Lordship.
Yes,
I have no objection, Your Lordship.
Mr. Learned Counsel.
It's a connecting
Appellant has
matters.
sought for accommodation on the ground that the learned conducting counsel, Miss P. Bersaji, is out of station. This will not be objected to by the respondent. Matters adjourned. This is matter after 3 weeks.
Is this connected with item number 12
So,
of the hearing?
12 also 3 weeks.
Yes.
Item number 2.
Please, Your Lordship. Your Lordship, I am appearing for all the respondents here, Your Lordship, and I seek for time, Your Lordship, to file a leave objection.
What is this Miss case about?
My lord, this case for grant of leave, my lord, for filing appeal.
Grant of leave.
Yes, ma'am. But this is appeal against acquittal by the trial court.
Grant of leave is required. Leave is required.
Leave is required, my lord.
Why would you object?
My lord.
I'm asking her,
taken
sir,
time
why
for-
would you object? That's a matter. It's a
Thanks,
matter
Your
of.
Lordship.
It's a matter of course.
Yes, Your Honor. 2 weeks, Your Lordship.
Last chance. They've taken quite some time.
The counsel for the respondent has sought for accommodation on grounds of personal difficulties. Dr. N. Musica, Larat DSGI, appearing for the applicant, has no objection to the premium. Accordingly, as prayed for, this is matter of the 3 weeks.
Highly obliged, Your Lordship. Item number 3.
Lord, we have taken steps upon the respondent, my lord. 4 to 12, my lord. I file an affidavit also, my lord. Factum of service.
Your Lordship, we were appearing for respondent 4, 5, 6, 8, and 12. We just filed our power today.
4, 5, 6, 8,
4,
and 12.
5, 6, 8, and 12.
And what is left?
So 7, 9,
9,
10,
10,
11.
9, 10, and
7,
11.
9, 10, 11, my lord. That's the case. Steps has been taken, my lord. Since some of them are appeared,
We'll wait.
my lord.
Mr. Al-Karim, Learned Counsel for the petitioner, has submitted that the notice issued upon the respondents number
4 to 12.
4 to 12 have been affected, and an affidavit of service in this regard has been filed. Next, Ms. Learned Counsel has submitted that she is entering appearance on behalf of the respondents. Respondent?
CL Maplang.
Respondents?
4, 5, 6, 8, and 12.
4, 5, 6, 8, and 12. However, no appearance has been made on behalf of the respondents 9, 10, and 11.
7, 9, 10, 11, my lord.
7, 9, 10, and 11.
And 11.
Accordingly, as prayed for, the appearance of such respondent is awaited. You'll file your counter. The respondents represented by Ms. have submitted that counter affidavit will be filed within the next date fix. As prayed for, this is matter of the 3
Your
weeks.
Lordship, I'm appearing for respondent 1, 2, 3.
They're yet to file, my lord, the counter.
I have to करते हैं जी जो Mr. appears for respondent 1. You have not filed your counter?
Obliged.
3 weeks.
Item number 4.
This is 4 to
7 numbers.
4 to 7.
No lordship. 4, 5, 4 to 10.
Item number
4 to 10.
4 to 10.
Item number 4 and 5 is same lordship. 4 have already concluded the argument lordship. Okay. Now only on the issue of law lordship, whether prior approval has been obtained or not. So in item number 5 lordship, so on the earlier occasion I have relied to judgment.
You are making submission in which item now?
Item number 5 lordship.
5.
Because 4 and 5 is same lordship, I have concluded my argument in item number 4. Now, so far as factual aspect is concerned, on the previous date I have completed. Now only on the issue of law lordship. on the previous date I have relied two judgment. One judgment my lord has passed in recent judgment lordship in 2023 lordship. Siljon A. Shangma 22 lordship. That I have read out the judgment, and apart from that I have given the copy of two judgment lordship.
Yes.
Yes, I have given. And one more judgment, Lordship, that is Delhi High Court judgment also, division bench judgment. Nisha Tegi. That Nisha Tegi is a judgment.
This Sijan Sama, which paragraph you are relying on?
Paragraph, Lordship, will be paragraph 9, 13, 14, 17, 18.
The other case?
In the other case, Lordship, here, because that other case, that Nisha Tegi is directly related to my case. The facts and circumstances in
That
those
also
cases.
you have given copy?
I have given, Lordship. Here, I have relied so many para. Why, my lord? Because that factual aspect in that case is directly relatable to my case, Lordship. Because the substance of allegation in that Nisha Tegi case.
Where is that copy? Not here.
On the date, Lordship, I have given. Two judgment I have given.
Is it reported?
It's reported, Lordship.
What is the journal?
This is, my lord, this is, although it is reported, I have printed it from SCC True print, Lordship, but it's reported in the 1997-41 DRJDB.
I don't have a copy with me here. This one I have, or the other one? Not here. That it's not here. You have a.
I have only one set, Lordship, because since I thought I have given. So I'll get it Xerox and I'll supply, Lordship. In the meantime, I can refer some other judgment, Lordship.
Just give the citation again.
Citation, Lordship, that 1997 within bracket 41 DRJDB.
41.
41 within bracket.
DRJ. J.
Delhi Report Journal, DB, Division Bench Matter, Lordship.
Okay. Then?
DRJ.
After that, nothing else?
No, Lordship, no. This is a Division Bench order.
No page number or nothing?
Page number is not given, Lordship, here. Then what I'll do, Lordship, here in this case, I'll try to find out the online SCC, Lordship. That will be.
You see, you get this common journal,
yes,
which would
Lordship.
be
Because since I have printed from SCC online, True Print, so better to print online, SCC online. That will I'll get the SCC online. That apart, Lordship, on the previous date I have refer Meghalaya Education Act, Lordship, 9(2), Lordship.
(1981).
1981, section 9(2). Because I have to submit my written submission, that is why I have just make one set for the court and one set for myself. I didn't make copy for the other set. There are so many respondents. So at the time of written submission, they can note down the citation in all. At the time of retention, I will supply all the copies to the other side, Lordship. Lordship will section 9(2), Lordship.
Yes,
May I read, Lordship?
please.
Page will be, Lordship, 27. 27.
No, I'm reading from this court, Meghalaya Education Court.
Yes, Lordship. I am also really same. Will be page 27, Lordship.
Yes.
Terms and conditions. They had not said terms and conditions of service of employees of recognized private school. This is the rule govern such schools, Lordship. Para 9(2), Lordship. On the previous date also I have read out. Subject to any rule that may be made in this behalf, no employee of a recognized private school shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise terminated, except with the prior approval of the competent authority. Now, our rule, our Act 1981 and the Delhi Act 1971 is the perimeter, Lordship. I can say the entire Act. This Act is a copy and paste from the Delhi Education Act. Only the number is changed, Lordship. Here we are 9(2), and in the Delhi Education Act is 8(2), Lordship. That is the difference. The rest is same. In that Delhi Division Bench order, Lordship, here the issue was with regard to the suspension, and they have relied Rule 8, and Rule 8(4) talks about suspension. Here Rule 9(4) talks about the suspension. In that case, the facts is same. Like here, in that case, Lordship, same the management committee, he was trying to deduct some money. He has taken some check. So when salary is given, then he has to withdraw the money, some amount from the so-and-so, from the account of the teachers. When they refuse, when they raise their voice, then some sort of allegation has come up against the petitioners. Like why you have refused to accept the letter, why you didn't refuse to accept the order. These are all those allegations. And the division bench of the Guwahati High Court has set aside the suspension as well as the entire proceeding, because the allegation in the charge sheet does not constitute that it was a good and sufficient cause or the reasons to conduct inquiry against those teachers. On that basis, the entire charge sheet was quashed and direction is given to reinstate or take back the teacher's concern. Now here I am relying only with the Supreme Court judgment, Lordship. This judgment has relied the earlier judgment of 2016 of the Honorable Supreme Court. I'll read out from para 5, Lordship. Para 5.
Yes.
Here also, Lordship, the management is the appellant before the Supreme Court and the aggrieved teacher is the respondent, Lordship. In her reply to the letters of the appellant school, the respondent number 1 denied the charge against her. Respondent number 1 is the teacher, Lordship, like me. After the period of suspension was over, the respondent number 1 reported to her duties. She was allowed to sign the attendance register but was restrained from taking classes. The respondent number 1 applied for leave, and on so she resumed her duties, but she was not allowed to perform her duty. A letter was issued to her by the secretary of the managing committee asking her not to attend duty from so, but she continued to attend school and took the classes. On so she was forcibly ousted from the school with the help of police, and she was asked to attend a meeting wherein she was threatened to face termination of service. On so she was served with a letter of termination annexing 2 checks. Assailing the order of termination, Lordship, the respondent, the teachers concerned, filed a writ application before the High Court. The learned single judge of the High Court by order dated so dismissed the writ petition number so on the ground that the school concerned was not a recognized private school by the state government but a privately managed primary school. This writ application was not maintainable. However, it allowed respondent number 1 to institute an appropriate suit for seeking relief claim in the writ petition. Basically, the writ petition was dismissed on the ground of maintainability, that because that school is not aided school or the recognized private school, so writ is not maintainable. So that is why the writ petition was dismissed. Challenging the dismissal of writ petition number so, the respondent number 1 appealed before the division bench of the High Court. The division bench, by order dated 31/2009 in Asha Srivastava versus State of West Bengal, allowed the appeal preferred by respondent number 1 and set aside the termination order and allowed the respondent number 1 to join the appellant school within 2 weeks with full entitlement of salary, allowances and other service benefit as per law. This order of the division bench has been challenged before this honorable court. First, Lordship, the teacher has challenged the order of termination. The learned single judge dismissed the writ petition on the ground of maintainability. Yes. Against that order, the teacher filed inter-court appeal. The inter-court appeal was allowed and direction is given to all the consequences benefits including the salary, Lordship.
Yes.
Now para 9, Lordship. That was the submission before the Supreme Court, Lordship. It was also submitted on behalf of the appellant, that is the school, Lordship, that the single judge or the division bench should have gone into the legality of the termination order and on the ground on which the termination order has been passed. The respondent employee was guilty of insubordination and using foul language as mentioned in the order of termination. The learned counsel also pointed out that the explanation was asked from the respondent employee, but she could not submit a satisfactory explanation and consequently her service was terminated. He submitted that he was hurt and there was no violation of principle of national justice. He also urged that no prayer was made in the writ petition for grant of back wages and the division bench has not assigned any reason for granting relief of reinstatement in the instant case. The learned single judge prayed that the learned counsel prayed that the back wages should not be granted in case of reinstatement part is upheld. That is basically they are justifying the order of the learned single judge, Lordship. That not justifying the termination, they were justifying, Lordship. Now, Lordship will come to para 13.
Yes.
This is another judgment of 2016, Lordship. I have not, because in the subsequent judgment, because some part of this 2016 judgment is relied in the subsequent judgment, which I am going to rely, Lordship. That is why that what is in Raj Kumar versus Director of Education, this court has held that section 8.2, my lord, the corresponding section will be 9.2 here, of the Delhi Education Act is a procedural safeguards in favor of the employee to ensure that order of termination or dismiss is not passed without prior approval of the Director of Education to avoid arbitrary or unreasonable termination, dismissal of employee of even recognized private school Moreover, this court also considered the objects and reasons of Delhi Education Act and came to the conclusion that the termination of service of a driver of a private school without obtaining prior approval of Director of Education was bad in law. This court observed on so and so that part, Lordship. We are unable to agree with the contention advanced by the learned counsel appearing on behalf of the respondent school. Section 8.2 of the Delhi Education Act is a procedural safeguard in favor of an employee to ensure that order of termination or dismissal is not passed without the prior approval of the Director of Education. This is to avoid arbitrary or unreasonable termination or dismissal of an employee of a recognized private school. This is para 14 also, they have more or less same, Lordship. Now Lordship will operative part, Lordship. My Lord will find page 21, para 21. Now the court has give the decision with regard to the maintainability also. That we are not here, Lordship, because the maintainability neither the state nor the other side has raised that issue. Para 21, in view of the aforesaid discussion, we have no hesitation to hold that the writ application is maintainable. Because the since writ petition was dismissed on the ground of maintainability, then appeal allowed, that even they raised the issue that it was not maintainable, but court has held that it was maintainable. Coming to the question of relief of reinstatement and back wages. In view of the factual matrix of the instant case, my Lord, para 22.
Yes.
We have taken note of the fact that the approval of the authorities concerned was not obtained and stigmatic order of dismissal was passed in the most arbitrary manner. It is not in dispute that no departmental inquiry was held. In that case, Lordship,
Yes.
they have taken a plea that departmental inquiry, since departmental inquiry was held, so in that eventualities, the approval is not required. In the present case, para 24, Lordship. In the present case, the employee has served for 5 years before the dismissal from service by a systematic order, passed without holding an inquiry. We cannot entertain the submission raised by the learned senior counsel for the appellant that back wages should be denied. The manner in which the termination has been made was clearly arbitrary and the order was illegal and void, and thus back wages should follow. Why I am referring, Lordship? Because here also, I made a prayer to make a salary from so-and-so to so-and-so. Here also I am praying for back wages. In the event the termination is set aside, whether I am entitled for back wages or not. In that judgment, they have raised that since there was no prayer, so back wages should not be granted. The court turned down the submission and has granted the back wages. Termination was set aside and the back wages was allowed. Now another judgment, this is very important, Lordship. This is very important judgment. Recent judgment 2023, Lordship. This is 2023 SCC online, Supreme Court 54. Page 54, Supreme Court. 2023 SCC online, Supreme Court, page 54.
Para?
My Lord, para 6, 7, 8, 12, 14, 15, 16, 17, 18. then 19, 20, 21. Because why I am relying most of the para, Lordship, just to stress the facts, Lordship. Under what circumstances the Supreme Court has given a decision, Lordship. It is submitted that even in the case of Marwari Balika Vidyalaya, Asha Srivastav, that judgment just I have referred, Lordship. The same judgment. After following the decision of the court in the case of Rajkumar Supra, it is observed and held that before termination, dismissing an employee, the prior approval of the Director of Education is required or mandatory, Lordship. It's mandatory, Lordship. It is further, here in this case, the aggrieved teachers is the appellant before the Supreme Court. It is further submitted by the learned counsel appearing on behalf of the appellant that the decision in the case of Rajkumar has been subsequently followed by the Delhi Education in the case of so-and-so, against which the special leave petition filed by the management has been dismissed by this court in the case of so-and-so versus so-and-so. Therefore, it is submitted that the division bench of the High Court has materially erred in restoring the order of termination by observing that in a case of non-aided institution and in case where the termination is after the disciplinary inquiry proceeding, the prior approval of the Director of Education is not mandatory. Here, whether the inquiry was as per law or not, that is different thing, Lordship.
Okay.
Because here also they have taken a stand. Since right or wrong, some inquiry before the termination, some inquiry was conducted against the teachers.
Hey, your point is proper procedure was not followed.
Not followed. So, my lord, apart from the DP, Lordship, apart from DP, assuming that the DP was done as per law, Lordship, everything was fulfilled. But my lord, on the previous date, I have argued how the DP was conducted. But that apart, Lordship, if there is a violation of section 9(2), then everything goes. Then everything goes, Lordship. Here, then my lord, I'll just read out just to emphasize the factual aspects in this case, Lordship. Making the above submission and relying upon the decision of this court in the case of Rajkumar, it is prayed to allow the present appeal. This is the submission of the appellant.
Yes.
Now, para 14. It is further submitted that even otherwise in the present case, the order of termination is not required to be set aside on the ground that prior approval of the so-and-so was not obtained. This is the submission of the other side.
Para 14?
Para 12, Lordship.
Yes.
This is the submission of the other side, because other side has taken a ground, although prior permission approval was not taken, but the DP was constituted as per law, and in the DP, the representative from the government officers were present. In that eventuality, even though prior approval was not, in that case, the prior approval is not required. So, that is the stand taken by the other side, because the DP was conducted by the district level officers. Here, the DP was conducted by the members of the managing committee without following due process of law. Now, para 14, Lordship. Para 14 is the operative part of the judgment. Making the above submission, it is prayed to dismiss the appeal. Now, at the outset, it is required to be noted that it is an admitted position that parties are governed by the Rajasthan Non-Government Institution Act 1989. Section 18. This case relates from Rajasthan High Court, Lordship.
Yes.
But the provision of Section 18, Section 8 of Delhi Act and Section 9 of the Meghalaya Education Act is perimetry, Your Lordship. Section 18 provides that no employee of a recognized institution shall be removed, dismissed, or reduced in rank unless he has been given by the management a reasonable opportunity of being heard against the action proposed to be taken, and no final order in this regard shall be passed unless prior approval of the Director of Education or an officer authorized by him in this behalf has been obtained. My Lord, this is same. The learned tribunal, the learned tribunal set aside the order of termination on non-compliance of Section 18 of the Act, inasmuch as before terminating the service of the appellant, the employee prior approval of the director was not obtained. The same came to be confirmed by the learned single judge. However, by the impugned judgment and order taking a contrary view, the division bench of the High Court has allowed the appeal and restored the order of termination. From the judgment and order passed by the High Court, it appears that before the High Court, that the decision of this court in Ras Kumar, that is 2016 judgment, Lordship,
Yes.
taking a contrary view and taken a view that before terminating the employee of a services or employee of a recognized institution, prior approval of the director is required, was pressed into service. However, though impermissible, the division bench, because in this judgment, Lordship, because although there is a settled position in 2016, which says that you cannot terminate without prior approval, despite there is a binding precedent of the Supreme Court, the Rajasthan High Court has taken a contrary view. So in that line, Lordship. Now the operative part, Lordship. Now this case, Lordship. Para 16.
Yes.
Now, so far as the decision of this court in the case of Ras Kumar is concerned, this court was considering the perimetry of provisions under the Delhi Education Act. This court was considering Section 8 of the Delhi Education Act, which reads as so and so. My Lord, 8.2. Here I have read out 9.2, my Lord. This is a perimetry provision. Similar to the provision so far as Section 18 of the Act 1989, this is Rajasthan. That is also same, Lordship, para 17. Removal, dismissal or reduction in rank of employee subject to any rules that may be made in this behalf. No employee of a recognized institution shall be removed, dismissed or reduced in rank unless he has been given by the management a reasonable opportunity of being heard against the action proposed to be taken. Next para is important, Lordship. Further, that no final order in this regard shall be passed unless prior approval of the Director of Education or an officer authorized in him behalf has been obtained. First line say that first you have to give reasonable opportunity. Even after opportunity, if prior approval is not obtained, that the termination will be illegal. In the case of Rajkumar, while dealing with the perimetry provisions under Delhi Education Act and after considering the decision of this court in the case of TMA Pi Foundation, it is specifically observed and held by this court that in a case of a recognized institution, before terminating the services of an employee, prior approval of the directors is required. Therefore, contrary view taken by the larger bench of the High Court relied upon by the division bench of the High Court is not a good law. In the TMA Pi Foundation also has taken a similar view. That is why I said that division bench ought not to have taken a different view. It is required to be noted that the division bench or that the decision of this court in the case of Rajkumar so and so has been considered by this court in the case of Marwari Balika Vidyalaya. I have referred, Lordship, that earlier judgment, and also by the Delhi High Court in the case of Mangal Sen Jain Supra. In the case of Marwari Balika Vidyalaya Supra, and this court considered the decision in the case of Rajkumar Supra and object and purpose of Section 8 of the Delhi Education Act in paragraph 13 and 14 as under. But this is Rajkumar judgment, Lordship, because in earlier judgment I have read out, Lordship.
These are all similar.
All similar, Lordship. Now, para 14, Lordship. That next page, Lordship. This is not para 14, this is a sub para of para 18, Lordship. The next page. This court has laid down in Rajkumar versus so-and-so, that the intent of the legislature while enacting the Delhi Education Act so-and-so was to provide security of tenure to the employees of the school and to regulate the terms and conditions of their employment. While the functioning of both aided and unaided education institutions must be free from unnecessary governmental interference, the same needs to be reconciled with the condition of employees of the needs to be reconciled with the conditions of employment of the employees of this institution and the provisions of adequate precautions to safeguard their interests. Section 8.2 of the Delhi Education Act is one such precautionary safeguards which needs to be followed to ensure that the employees of educational institutions do not suffer unfair treatment at the hands of the management. Even on fair reading of Section 18 of the Act, we are of the opinion that in the case of termination of employee of a recognized institution, prior approval of the Director of Education or an officer authorized by him in this behalf has to be obtained. In Section 18, there is no distinction between the termination, removal or reduction in rank after the disciplinary proceeding or inquiry or even without disciplinary proceeding or inquiry. As per the settled position of law, the provisions of the statute are to read as they are, nothing to be added or taken away. The words used are no employee of a recognized institution shall be removed without holding any inquiry, and it further provides that no further order in this regard shall be passed unless prior approval of the director has been obtained. The first part of Section 18 is to be read along with first provision. Under the circumstances, taking a contrary view that in case dismissal removal of an employee of a recognized institution, who is after holding the departmental inquiry, the prior approval of the Director of Education is not required, is unsustainable, and to that extent the judgment of the larger bench of the Rajasthan High Court in the case of so-and-so is not a good law. Therefore, on true interpretation of Section 18 of the so-and-so, it is especially observed that and held that even in case of termination, removal of an employee of a recognized institution, after holding departmental inquiry, proceedings, prior approval of the Director of Education has to be obtained as per section proviso to Section 18 of the Act. In view of the above, and for the reasons stated herein above, the influence judgment and order passed by the division bench of the High Court restoring the order of termination, which as such was without obtaining the prior approval of the Director of Education, deserves to be quashed and set aside, and accordingly quashed and set aside. The order of the learned tribunal setting aside the order of termination confirmed by the learned singles is hereby restored. Consequently, the appellant shall have to be reinstated in service, and considering the fact the respondents and are an unaided institution, an order of termination was passed as far as back in the year 1998, we direct that the appellant shall be entitled to 50% of the back wages. However, he shall be entitled to all other benefits notionally, including the service if any. Here also back wages granted, Lordship. Now, why I am referring, Lordship? Because if my Lord will see the counter affidavit of the government, Lordship.
In this case?
Yes, Lordship. Because item number 4 and 5 is identical, Lordship. Even the page number also more or less same.
Okay. Affidavit of respondent?
Respondent number 1, 2, 3, Lordship. My Lord has got it.
Yes, 29/7/17.
Yes, Lordship. This was filed on 24th of July 19.
Okay.
Para 17, Lordship. Para 17, there is a categorical admission.
Yes.
Para 30, in my writ petition, Lordship, I have referred the in-prin order saying that no approval was obtained.
Yes.
In reply to the para, the government, Lordship, that with regard to the abatement made in para 30 of the writ petition,
You are reading para 17?
para 17,
Yes.
1-7. This is very important para, Lordship.
Okay.
The answering respondent states that the dismissal of the petitioner was done by the respondent number 4 and 5, that is the school principal and the management, and was done without the approval of the competent authority. The letter of approval quoted in the order dated so and so appears to be irrelevant and invalid. Therefore, the order of the dismissal of the petition is illegal. My lord, when the statutory law says that you have to do certain act in that particular manner, there is no option. He has to act on it. Otherwise, the action will be illegal, Lordship. Now, Lordship, now here, in place of the petitioner, the private respondent has been appointed, Lordship.
Yes.
You can Xerox, no?
So the respondent, see, the official respondent, that is the
approving authority.
The approving authority in the education department, they themselves say that the dismissal is illegal.
Illegal.
So they are,
Lordship, because now why they are saying illegal, my lord may recollect, while suspending, they have taken a approval of 2018.
yes, that 2018 and 16.
Yes. Now, while dismissing, they have referred the order of my lord in the counter affidavit. They have been 4/11/2016. You cannot. You have to take. Now I have my misconduct is of today. Now you cannot take a decision for my misconduct way back in 2016. So that is what categorically admitted that yes, that leaving apart the other aspect, Lordship, whether the DP was constituted as per law, this and that. Even on that ground, Lordship, my lord, in all the Supreme Court judgment as well as the High Court judgment, they never look into the DP, whether DP was as per law or not. Even the DP was as per law. But that is why the management has taken a plea that since we have taken a DP, in that eventuality, then prior approval is not required. Court has turned down the submission. So no, even after DP, you have to take. Once you fail to comply this mandatory provision, then it will go. Now, Lordship, this one, please. Now, Lordship, here the private respondent has been appointed in my place, Lordship.
Yeah.
The private respondent number 6, Lordship. Now, so far as the legal aspect, my lord, with regard to my termination is concerned, I have covered with this judgment, Lordship. Now, in the event, Lordship, if my lord find that the order of termination is illegal, then what would be the consequences? to those teachers
who have already been
who
appointed.
already been appointed. Now Supreme Court says that when the superstructure, when the foundation gone lordship, the superstructure automatically falls. There are certain judgments, the Supreme Court says that even they are not a necessary party. Why lordship? Here I have come against the order of my termination, whether my termination was legal or illegal. When I was terminated, their right has not been accrued, lordship. They did not have an independent right. Now they cannot say, they cannot come and say that yes, the managing committee has rightfully terminated the petitioner. They cannot, because they have their own independent rights. No independent rights here. Here only I am on the legality and illegality of my termination, which they cannot, neither they can support nor they can go or justify my termination. So I'll rely some judgment, lordship. Here I'll rely one judgment, lordship. My lord has passed the recent judgment in 2023. Now NCT, there is an NCT file. NCT prescribed that for appointment in any secondary schools, that B.Ed is compulsory.
Yes.
Now here all the teachers who have been replaced, the petitioner herein, except one, the none has completed the course of B.Ed, lordship.
So that NCT norms have not been
Not
complied with.
that is. This is another aspect. Now,
But that too you have to challenge.
yes,
Are you challenging?
I have implemented and I have amended the writ petition. Even the Supreme Court, in fact, lordship, I'll try to satisfy the judgment. One judgment I have, that is also only the position will be that petitioner respondent will be the situation will be different. The factual aspect is same. In that judgment, lordship, in that judgment, petitioner was appointed earlier. Then the respondent has challenged his appointment. The tribunal has set aside the appointment. Now that order has been challenged by the appointed teachers. Now during the pendency, lordship, the respondent was appointed. Now the matter went to the Supreme Court. Now Supreme Court has set aside the order of tribunal, lordship. Now the issue came. Then what would be the consequences of the person who has already been appointed? The Supreme Court says that when the initial action itself is illegal, the consequent action all will go. Well, that part I'll submit on the next date, lordship, because on the next date, lordship, that with regard to B.Ed as well as that the appointment of the private respondent, lordship. Because, lordship, I have made only one set of the judgment, lordship, because I cannot.
So you are done for today?
Today, lordship.
Yes, what would you have to say?
Yeah. So I will be making the submission, Your Lordship, after the state is completed. State and
Lordship, I can start my submission, but if I make my submission, it will be damaging to the case of the other private respondents. So
obviously he cannot go against the records.
So let them start. Yes, lordship.
My lord, here item number 3, 4 and 5 is identical, lordship. Initially suspended, the termination. And item number 5 and 6, lordship, the documents will be the same, lordship. Here direct termination, lordship, and the termination has been set aside by the director. And against that order, lordship, neither the state nor the management. That means once the termination has been set aside, now I am in service. Here I am asking for salary. The other two matter also same, lordship. Neither I was terminated nor anything. They are not giving the salary. The documents I am relying more or less same, lordship. So factual aspect, I don't think that I need to highlight the things. So other matters, once I complete this matter, other matters will not take much time, lordship. Because I am not going to refer all those documents in all, my lord. So this is the only, because here once that third party that writes how to handle that other party's lordship, that is the that replace teachers, that will cover the other matter also, lordship.
Then you'll have to continue with your submission.
Yes, in item number
with
2.
With your
Two, lordship, yes. I'll continue.
All the allegations against the private respondent, so let the private respondent
Let him
start.
complete. Then he has to complete. Otherwise, it'll become
Yes, lordship.
Yes, yes, lordship.
But why not continue now, Mr.
Lordship, I have, because I am relying. Otherwise, I have relying some judgment, lordship.
Oh.
So on that day, I'll try to complete item number 3 and 4, lordship.
4 and 5.
4 and 5.
Heard, Mr.
I'll not repeat today's argument, lordship.
Yes, heard, Mr. S. A. Sheikh. Letter counsel for the petitioner. Hearing is not concluded and will continue on the next day fix as prayed for. This is matter to 2 weeks.
Hello, please.
Item number 14.
This is a NOCMA matter, lordship, here. This is a NOCMA matter, lordship. Here, lordship, the case has... Is there?
Yes, your lordship is coming. SD will be coming.
Okay, you start. How many respondents are there?
There are 3, lordship. Then private respondent is not being represented, lordship, despite the service of notice is being completed, lordship.
Oh. 2 and 3.
2 and 3, lordship. Otherwise,
matters proceeded ex parte.
Because as per the order 25/4/2024, lordship, only it has been recorded that despite receipt of the notice, none.
But have you filed your the affidavit of service?
Yes, lordship. My lord will kindly see the order at 25/4/2024.
It has not proceeded ex parte.
Lordship, but it has been recorded that despite receipt, they
No,
not.
that is, they may have received, they may take some time to file, to engage a counsel.
My lord, yes, there is no such order proceeding ex parte against them, lordship. My lord, then on the next date, lordship, my lord can pass necessary order, lordship. Because tomorrow, yes, obviously, if there is a judicial order, lordship,
Because of the passage of time,
they are not coming,
it
lordship.
would be better if you take fresh steps.
All right. All right.
This, what is the case again? You said NOCMA.
This is fight between NOCMA ship, lordship. Here in the earlier round of litigation, here the petitioner number 1 and 2. Petitioner number 1 is the NOCMA and 2 is the husband of one NOCMA A, of Aking A. And the respondent number 2 and 3 is husband and wife of Aking B, lordship. Now the predecessor of the petitioner as well as the respondents, lordship, they had some litigations were pending, litigations were there. Then ultimately, now both the predecessor, that is the petitioners as well as the respondent, died. And while some litigation was pending before this honorable court, Lordship, now after that what happened, after the demise of the predecessor, Lordship, the Nokmasif devolves upon the surviving daughter's Lordship. Then they have reconciled the matter, Lordship. Then the respondent issued a NOC and recommending my name for the Nokmasif of Aking A, Lordship. So against that only I have.
What I could have understood, my lord, is this. There was a claim and counterclaim over a portion of land where the petitioner is claiming to be the Nokma. But due to the pendency of the litigations and all, my lord, that was not decided. One of them, they expired, my lord. Then what happened? A new Nokma was substituted and he has given an NOC to the private respondent. With that NOC, the private respondent has gone to the district council.
So practically he has conceded.
Yes, for registration, my lord. Now, at that point of time, my lord, is 2023 matter. At that point of time, my lord, that application was not entertained. Today, I have taken a fresh instruction from the EM Revenue, who is the Deputy CEM of the District Council. He said, my lord, if the petitioner wants, he can, my lord, approach afresh and will decide. If in case he is entitled, his name will be registered, my lord. Because it is the District Council EM who will decide whether he can become a Nokma or not. So only they have come, my lord, for a direction, for a direction that to register their name. But I understand, my lord, that that direction may not fall from this honorable court.
Yes.
Only, my lord, may direct us, my lord, that to consider his case, my lord,
then
and to decide the matter.
You see, it is you see, more or less.
Yes.
It is in the form of let's put it this way, representation, which is to be considered.
Yes, Lordship.
So now they are you see they are contemplating to consider your application.
If that is the stand, that is the stand, my lord, on the next date, it can be disposed of, Lordship.
We dispose it now.
Today, Lordship,
Dispose of. But only thing is this, my lord, it is not that by this direction, my lord, he will be entertained to become a Nokma.
No.
We will consider it.
See, Mr. Adi, I say consider.
Yes, my lord.
His application, including the NOC, will be considered by you.
Yes, exactly.
Whether you feel that he is likely to be
entitled or not.
Yes, where is the application?
Lordship will find the application at page.
Including that NOC?
NOC will find at page, Lordship. NOC is page 37, Lordship.
First the application.
Page 37 is annexure 6. Is a handwritten, my lord. The type copy is on page 38.
Where's the NOC?
NOC is page 37, Lordship. Here the respondent has signed, Lordship. Page 37, the type copy will be page 38, Lordship.
38 is NOC? 38 is your application?
Yes, in my application. 37, Lordship.
38 is the type copy?
Yes, type copy.
So this is application to appoint?
This is the NOC, Lordship.
No. Your 38 reads appointment, application to appoint
new Nokma.
This is the application.
As well as NOC from the...
Where is the NOC?
This is that, my lord, here also. Because the respondent has signed here, Lordship.
Signing means, you see, it's a different thing.
And page 36 is from the Mahari, Lordship. The handwritten one.
See, Mr. Sheikh, I have not gone through the petition. I am made to understand that as far as Aking A is concerned, you have filed this application before the district council for being appointed as Nokma.
Yes, Lordship.
Okay. Now, as far as the respondents are concerned, they have also filed a no objection.
Yes.
So that has to be there.
My lord will find page 36 sub-para lordship. This is from NOC from the Mahari. Page 36, subject, after that last para lordship. That sir, it is our Manda Mahari decision. We are unanimously decided in the Mahari meeting there's name for new Nukma appoint of the so and so. So there is no complaint or any kind of objection against them. Sir kindly appoint them as new Nukma of Tinajekri Aking. And the next page, joint application. The petitioner as well as the respondent lordship.
Who is this Mindil M. Sangwa?
This is one of the Mahari. Because that has to come from the Mahari.
What I understood from the petition, my lord, if my lord may kindly peruse page 38. Page 38 appears to be, my lord, this is a joint application filed before the by this Nokma, both the side, my lord. Now, my lord, may kindly say serial number 1, Minang Momin.
He's the respondent.
He is the respondent number 2.
Yes.
So it appears that they have filed a joint application. But now, my lord, what my submission was this: if they are entitled, my lord, we will consider, but let them file a fresh application.
But why have you made them respondent?
My lord, because some rights against them, obviously, because they have
rights or no rights. See, they are on your side.
Yes, lordship.
You have jointly filed this application. It's for the district council to
My lord,
consider.
at this stage, what I may be allowed to file a fresh representation, lordship, and they may consider, lordship.
Not representation is a petition. They have to file a petition along with their claims. We'll dispose it of,
My lord,
or we'll pass necessary.
Then we'll do a thing. You withdraw this petition. Withdraw this petition with liberty to file an application before the
Yes,
appropriate.
that can be done, my lord.
Then you file a fresh application.
Yes, my lord.
Otherwise, you have made your own men. You have made them respondent. I fail to understand.
Because he's the Aking of, he's the Nukma of
But why?
Aking B, lordship.
He may be. No,
Yes, lordship.
You see, we don't know. You see, this is not a. You see, the issue here is not to consider his locus or his status.
Then comprehensive application on representation and the direction that they should consider my.
That is.
Yes.
That liberty
Then you
is
file
always there.
You file a fresh application before
Yes,
them.
Yes, lordship.
File a fresh application.
My lord.
Withdraw this.
My lord, some observation may be given.
Yes, I'll give you.
Yes.
You are at liberty to file a fresh application before
the EM revenue.
And certain that they can, in the event the representation is filed, lordship, they can take a decision within a certain period, lordship.
That is up to them. It's not for me.
My lord, sometimes what happens, lordship, because I have experienced when so many representation and so many letters were filed. But
this will be a quasi-judicial proceeding, my lord. We have to pass an order.
That is a procedure.
My lord may kindly record my submission also. That will be quasi-judicial, my lord. It is not an administrative order.
True.
My lord, if some certain, so lordship, liberty.
Mr. Sheikh, learner counsel for the petitioners, have submitted that the petitioner, along with the respondents number 2 and 3 herein, have filed a joint application dated 14/10/2019. Before, you have not even
For appointment
There's no
of
address here.
to the
Just village so and so. I mean, this translated copy says.
Yeah, it appears that they have done like this kind of application was
Well,
submitted.
it must be addressed to somebody, isn't it?
my lord. That is why I am praying that.
No, it is there, my lord.
Is there?
It
Is there? Page
Page
36,
36,
lordship.
Page 38.
36 from the Mahari lordship.
Okay.
This,
This is the
the letter of
application.
page 37 was enclosed along with page 36, my lord.
Okay, okay. So it's okay.
No, this is not an enclosure,
Very
lordship.
confusing. So, kunum to go. And dated 3/9/2019.
Yes, lordship.
The joint application. Uh,
3/9/2019 is a application from the Mahari lordship.
that's what.
And
Very confusing.
yes, that subsequent application is from joint application lordship, although it has not been addressed to the EM or CM.
Why would it be so? See, if it is of same date, you can see that
Yes,
it's
annexed.
attached. Yeah.
Attached. Yes,
But
lordship.
it's not.
No,
No, one is of October.
This is October.
NOC was granted
Yes.
in October only.
I think even here, Mr. Sheikh doesn't look proper at all. You have failed to even identify the authority.
My lord, what I am praying, lordship, then liberty may be given to file a new application before the lordship.
Okay, you do that.
Yes, lordship.
So Mr. Sheikh Land Council for the petitioner has submitted that, has made a prayer that the petitioners may be allowed to withdraw this petition with liberty to file a fresh application before application before the concerned authority.
Before the EM revenue, my lord.
Concerned authority, that is the executive member,
Revenue, within the revenue.
revenue, GHADC, Garo Hills Autonomous District Council. Mr. SD, Larat Standing Council, GHADC has no objection to the submission made. Accordingly, on prayer so made, this petition is hereby dismissed as withdrawn, with liberty sought for allowed.
My lord, only one observation in the event that some to dispose my application as
that will touch on merits.
No, my lord, no. If I file a application, lordship, if certain, I am not saying that within 1 week or 2 weeks, so that only for direction. I am not saying that consider my application. I am not saying consider my application, no, lordship.
That is not. You see, once the matter is closed, it's not within the realm of this court. You know better. If they delay, then you come before this court.
Masuk.
Any mention?
Lordship, I beg to mention item number 19 of the main list, Lordship. I'm praying if this matter can be taken up after 2 weeks, Lordship. Lordship, I've already informed the other side.
I am here, my lord.
So when do we have it?
After 2 weeks, Lordship.
2 weeks.
After 2 weeks, Lordship.
Mr. Learned Counsel for the appellant has sought for accommodation on grounds of personal difficulties. Accordingly, as prayed for, this is matter for the matters adjourned. This is the same after 3 weeks. So you get more time to prepare,
Hey, my lord, with the consent of the other side, I beg to mention, my lord, item number 18 of the main list, hearing matter, my lord. In this case, I am appearing for the FCI respondent, my lord. May this case be taken up on 27th of October, my lord. Some personal difficulties today, my lord.
Who is appearing?
They are also from property, my lord.
Okay,
I have taken consent.
Okay. No, we'll not. 20.
My lord.
2 days. 27 will be 4 weeks. So we'll do one thing, Mr. Singh. We'll not give a fixed date. We'll say that the matter will be listed after 4 weeks, because at that time we never know. Anything can happen. Change of
Yes, my lord.
There may be change of bench also.
Yes, ma'am.
Mr. B.K. Singh, Learned Counsel for the respondent. Respondent what?
Respondent, all the respondent, my lord.
All the respondent has sought for accommodation on grounds of personal difficulty. The accordingly, as prayed for, this is matter of 4 weeks.
Obliged, ma'am.
Yes.
From daily list, item number 1.
May it please your worship.
Yes, Mr.
Lordship, these batch of matters, Lordship, have been mentioned today, Lordship, to be mentioned for fixing it on another date for taking up for hearing, Lordship. So, Lordship, I am praying if this matter can be taken up on 6th, Lordship. 6th of October, Lordship.
As my brother
Subject
said,
to Lordship's convenience.
we will not give any fixed date.
Lordship.
Because we don't know.
Lordship.
Yes, my lord. Lordship may have it after 10th, my lord. Any day after 10th, my lord. 6th, I am in some difficulty, my lord.
1, 2. After 3 weeks, then?
Lordship.
After 3 weeks, my lord. After 3 weeks, my lord.
Mr. Learned Counsel appears for the appellate. Learned, you appear as AG?
Senior advocate, my lord, or AG also is fine, my lord, because a public sector undertaking of government of Meghalaya only, sir. The company of government of Meghalaya.
Mr. A. Kumar, Learned AG, is also present on behalf of the respondent. All respondents?
Your Lordship, I am for the respondent commission.
Okay.
Respondent number 1, Lordship.
Respondent number 1. This appears for respondent number?
Number 1, Your Lordship.
You're for 1?
Yes, Your Lordship.
Mr. Kumar is for whom?
I'm assisting Mr. Siddharth, Your Lordship.
We're both for the respondent commission.
No, okay. Mr. Siddharth would be for respondent number 1, but Mr. Kumar would be for respondent number 2.
Yes,
all utilities, Lordship, is being represented by Mr. Advocate General, Lordship.
Okay.
Lordship.
For the commission only. Fine. Unum to respondent 2 I think Baro. It is the Learned Counsel has submitted that this matter is posted today for fixing the matter, for fixing a date for hearing of the matter. Accordingly, as prayed for, this is matter for hearing after 3 weeks. we mention.
When you keep something just before judgment, it's some clarification.
Item number 9.
May it please, Your Lordship.
Yes.
In item 9, my lord, the SLP of the appellant has been dismissed, my lord.
Where is that?
And
Oh, that's
because against the order of your lordship.
That's for implementation of the Dorbar.
My lord, the order is let's just go. The order passed by Supreme Court. Lordship, Supreme Court declined to interfere the order passed by this honorable court. My lord, number 2, we are not inclined to interfere with the impugned judgment order passed by the High Court. Especially petition is accordingly dismissed. However, taking into consideration that the matter is pending between the parties for a long time and pertains to payment of compensation, we request the High Court to take up the matter expeditiously and decide the same as early as possible. Since the implementation is required, my prayer today is either direct the registry to correct the cause title. Now the 4 headmen will become party. They'll become respondent number 14, 15, 16, and 17. And allow me to take steps. I'll take within 2 days. And issue notice to those headmen. That order, Lordship, can kindly see the order passed by this court on 29/2/2024 in Miss Case number 2 of 2024.
Miss Case?
Yes, my lord. So those 4 headmen will become respondent number 14, 15, and 17. So within 2 days, I'll take steps. Order dated 29/2/2024. Especially para 7, in the result, the applications and such for implementing this order as read for. The headmen shown in the implementing application are implemented as respondent number 14 to 17. So registry may allow to correct the cause title. I'll take the step 2 days.
Heard Mr. H.L. Sankisu, Learned Senior Counsel, hearing for the appellant. Also heard Mr. A. Kumar, Learned AG, along with Mr. Indishwara, Learned AG, and Ms. C. Kulni, Learned GA, for the respondents. It is the submission of the parties that this court, by order dated 29/2/2024, passed in MCWA number 2 of 2024, at para 7 of the same, directed for implementation as party respondents 4 of the headmen.
Yes.
Of headmen of what?
Four villages is reflected in the Miss Case application.
4 of the headmen of 4 villages.
Yes.
To be implemented as respondents number 14 to 17 respectively. In the said order, it is also there is also a direction for notice to be issued upon the said implemented respondents. Next, this order was assailed by the appellant herein before the Honorable Supreme Court, wherein by the order dated, what's the order? 8/9/2025, the Honorable Supreme Court, in special leave to appeal, Advocate C number 9866 of 2024, had dismissed the said petition effectively, upholding the said this court's order dated 29/2/2024 supra. At this juncture, the learned senior counsel for the appellant has submitted that he may be allowed to take steps for issuance of notice upon the said newly implemented respondents. Pray aloud. Registry is directed to make necessary correction in the cause title of the appeal, and the notice issued is hereby made returnable within 2 weeks. List the matter thereafter.
Lordship, there is a Miss Case number 77 of 25 that required to be disposed of, Your Lordship. Miss Case 70 along with Miss Case number MCWA 77 of 25, Your Lordship. Filed by the appellant. That required to be.
What is the?
We are not pressing, my
Lordship, that is for deferring the hearing of this instant writ appeal.
only my lord during the pendency of the matter before Supreme Court.
In view of
the
this,
government press for early disposal.
in view of the said order of the Honorable Supreme Court, the
Miss Case 77, Your
Learned
Lordship.
Senior Counsel for the appellant has submitted that the application registered as Miss Case number 77 of 2025 is not pressed.
Yes.
Accordingly, the same stands disposed of.
Apply, Your Lordship.
Item number 10.
People
Very pleased, Your Lordship. It was admitted on the earlier occasion I was absent. So let the paper book be prepared for the legal aid.
Legal aid. Keep your records. Records have come.
Yes.
Same order as the earlier. Same order. I think I could take it. Oh, legal aid matter. Sorry.
Legal aid matter.
So I know only registry is directed to prepare the paper book. This is matter after 3 weeks.
I'm taking assistance of them.
Mr. S.P. Hemanta, legal aid, Learned Senior Counsel, who is also the legal aid counsel, assisted by Mr. has submitted that the trial court's record have since been produced for this court, and has prayed that that paper book may be directed and prepared. So I have to receive this directive.
Much obliged.
Item number 12.
Yes, Your Lordship. Lordship, this is a criminal appeal, Your Lordship. The trial court have been called for, Your Lordship, and it's a legal aid matter, Your Lordship.
Legal aid?
Yes, Your Lordship.
Same order will be passed.
Same order.
I can do you been more.
What's about, Your Lordship?
Item number 17.
নাম দেখাচ্ছে চলেন